cannot be made out of thin air, and denying security clearance on the basis of views produces a chilling effect on free speech and press freedom. The court has made it clear that independent press is vital for the robust functioning of a democratic republic. Ashmit Kumar, who's been tracking that hearing in court, joins us now to take us through this very significant order that's come in from the Supreme Court. Ashmit.
Well, as you clearly pointed out, this was pertaining to MediaOne, a company whose security clearance has been denied by the MHA. Subsequently, they moved the court, and that is the subject matter of consideration before the top court. The top court, in terms of relief being granted, has directed for the MHA to go ahead and to grant that security, nor to the channel to resume its normal functioning. However, there were three key findings that the Supreme Court has arrived at. The first key finding and the takeaway here is the cavalier manner in which the centre has been invoking national security. That is something that the Apex Court has taken objection to. In fact, the Supreme Court took this opportunity to remind the centre that mere invocation of a national security is not something that will keep the judiciary from investigating and applying its scrutiny into certain areas and questions that merit such scrutiny. Further, the centre, in fact, the Apex Court went on to say that national security claims need to be justified by some material. They cannot be invoked out of sheer thin air. That's the first key finding. The second key finding is with respect to what content qualifies as anti-establishment. Now, the centre in its submissions before the top court had said that the channel's portrayal of security and the central government, soft attitude towards Hindus in the Babri case, portrayal in cases such as the CAA, UAPA, NRC, this qualifies as anti-establishment. Here, the Apex Court held that none of this content qualifies as anti-national, and the mere fact that there is an understanding of the word anti-establishment, it suggests that there's an expectation by the centre of a certain kind of portrayal, which is what leads us to the third key takeaway, and this is with respect to independence of the press. Here, the Apex Court said that the homogenized view of the society on political issues is something that can be detrimental to the democracy, and it's important that for free and fair functioning of a democratic setup, there's a free press which enjoys the freedom to go ahead and to ask questions and hold those in power accountable by asking tough questions and shining the light on them. So three key takeaways from today's judgment.
Well, Ashwin, many thanks for wrapping up and giving us that comprehensive summary of what transpired in court today and that very significant order that's come in from the Supreme Court bench headed by the Chief Justice himself. To take this discussion forward, we're joined by Dushyant Dave, Senior Advocate of the Supreme Court, petitioner, arguing for the petitioner in this matter. Mr. Dave, many thanks for joining us here on CNBC-TV18. Let me start by asking you to explain to us what you believe will be the implications of this judgment that's come in from the Supreme Court by a bench headed by the Chief Justice himself, in the short term, in the medium term.
Well, it's a historic judgment in the sense that after Prime Minister Modi has taken over, the Supreme Court has been very slow and I would say somewhat very kind to the government in not, criticizing the government or not certainly overturning the government's views and government's orders in given situations, even if those orders were found to be unconstitutional, arbitrary and illegal. So this is a very historic judgment because it, as you rightly summarize, it really involves, several fundamental issues. And, freedom of press is one. Then, of course, there is this, sealed cover jurisprudence, which has been developing in this country in last 8 years, where everybody, appearing for the government from the lowest court to the highest court, wants to give something in sealed cover to the judges to please their mind, not disclose it to the petitioners or the accused and their lawyers, and, get away with of murderous orders. Now, the Supreme Court has come down very heavily on that jurisprudence, saying that this strikes at the very basic feature of the Constitution and it takes away from the citizen their right of judicial remedy, which is very fundamental. So that's a very, very serious pronouncement by the Supreme Court. The second, of course, freedom of the press and what these words which are used by Chief Justice Chandrachud, I must say these are far-reaching words. He says in one sentence everything that has to be said. He says a homogenized view on issues that range from socio-economic polity to political ideologies would pose grave dangers to democracy. Now, this is what we have to remember, that all that we are getting in the press, essentially electronic media and even the print media, is homogenized view by and large. I mean, there are exceptions. I'm not saying entire media is homogenized. No. But this is a clear warning to the press also that, yes, you can't give homogenized views because that will really amount to killing the democracy. So while upholding that, press freedom is very crucial to democratic society because it shines a light on functioning of the state, the court does administer a warning to the media. Thirdly, what the court has done is something remarkable. The court says that, you can't just allow this kind of national security as a bogey to deny citizens' rights. In every case, you see that government just stands up and says national security. The judges have said by taking up this refuge, you are definitely striking at the very basic character of the Constitution. You are denying citizens their right to challenge the governmental actions. So I think this is very, very crucial judgment coming as it does at a time when this country certainly is witnessing tremendous, I would say, erosion of press freedom, tremendous erosion of fundamental rights of citizens, and tremendous erosion of constitutional institutions, including the judiciary. So I think this is a great message that Chief Justice Chandrachud and Justice Hima Kohli has given to the country, and it will really go a long way.
Well, you are hopeful that this message that's being sent out by the Supreme Court today by way of this order will go a long way. But let's look at the case that was taken up today, which has led to this particular order itself, Mr. Dave. I want to understand from you whether the message is going to be heard loud and clear by the lower courts. This matter was taken up by a single judge bench. It was upheld by a division bench as well, which then finally led this matter to come to the Supreme Court by way of an appeal. So do you believe that this message is going to percolate down to the lower courts and also to the law enforcement agencies? I mean, one of the most egregious cases that we've seen in the recent past is the case of Siddiqui Kappan, jailed for 28 months, released after being jailed for 28 months on bail after an order by the Allahabad High Court. Do you believe that this message will percolate to law enforcement and the lower courts?
Well, it's not easy, to assume that it is going to percolate straight down. But certainly in this case, the Supreme Court has really, I would say, reminded the single judge and the division bench of the Kerala High Court that what they have done is absolutely wrong. Because what they have done is that by reading through the sealed covers which were presented before them, they have denied the MediaOne channel their fundamental right, and then they have made that right a completely nugatory. So I think there is a message which has been given by the Supreme Court. And I'm sure judges across, what is important, Shirin, for us to remember, that ultimately this is the Chief Justice of India, and he is here to stay for another 1.5 years. And every judge must understand that when Supreme Court speaks, it's the law of the land. But when the Chief Justice particularly, speaks on important issue like this, which goes to the very survival of democracy, then I think I would say it will embolden many judges across the country who have remained silent out of fear or out of sheer, I would say, being just simply not willing to venture into controversial areas. So I think this will definitely give a very powerful fillip to their courage. And I have no doubt that with the passage of time, perhaps this judgment will really open up new vistas for judiciary across the country.
Mr. Dave, you rightly pointed out that one of the most significant aspects of this case is the fact that the Supreme Court has once again come down very heavily against sealed cover jurisprudence. And this is not the first instance in the recent past. We saw the Supreme Court take this position in the Orope case. We've seen the Supreme Court take this position in the Adani Hindenburg matter as well. The Chief Justice again saying he is personally averse to sealed covers because he believes it is anti the principles of fair justice and transparency. With today's order and the comments that have come in the recent past from the highest court of the land, do you believe we're finally coming to the end as far as the sealed cover jurisprudence is concerned?
I have no doubt about it, because Chief Justice Chandrachud has made his views very clear on this. Even when we got the interim stay from the Supreme Court, from a bench presided by Chief Justice Chandrachud, then he had made it very clear that I disapprove. And in fact, one of my fundamental arguments was that Chief Justice, we have to lay down now law for that. We can't have this kind of a jurisprudence in a democratic society, that we are. unfortunately, it is Chief Justice like Chief Justice Gogoi who really brought this, I would say, dark jurisprudence into the Supreme Court. And in many cases, like CBI director's removal, the Rafael case, and many cases, Justice Gogoi went ahead and got this kind of seal cover, and he praised them himself along with his brother judges. And I'm really sorry to say that some of the good brother judges sitting with him agreed to that nonsensical procedure. So it was he who really did it. Chief Justice Chandrachud is a visionary. He is an intellectual giant. There is no doubt about it. And he believes genuinely that justice must be as open and transparent as possible. So it is part of his larger thinking that he is now spoken in this judgment. And I have no doubt that this is going to be the law for a long, long time to come. And I have no doubt that Supreme Court in subsequent years and the lower judiciary now will be definitely, I would say, slow, if not completely reluctant to accept such seal covers.
Sir, since this is a matter pertaining to press and journalistic freedom, let me ask you what this could imply for cases that are currently sub judice. I mentioned one individual, a journalist who is now out on bail as per an order of the Allahabad High Court. Recently, when a question was posed to Parliament by Lok Sabha MP, the response from the government was that the government does not have, the NCRB does not have data on how many journalists have been arrested on account of the UAPA, the IPC, etc. So we don't know the numbers at this point in time, at least if one goes by the response to Parliament. What could this mean for matters that are currently sub judice involving the press?
It will, I have no doubt that this judgment will be referred to and relied upon by lawyers in all cases in which this, seal cover jurisprudence is sought to be invoked by the government. So, and when the government wants to withhold the information from the petitioner or their lawyers and only share it with the court. So I think I would say that so far as Supreme Court is concerned, that kind of an I would say approach by the government is a matter of past now. And I don't think any judge in Supreme Court is going to entertain that kind of a request of the government. So government will have to come out and openly place the material. More often than not, we have seen, at least my experience shows, and I appear in large number of cases where human rights violations are concerned, that more often than not, the material that government produces to the back of the petitioners and the lawyers is generally wholly insufficient to justify detention, any kind of a decision of the government, whether it is detention, arrest, or action against anybody. So I think now government will have to really file affidavits, put the entire material before the court, allow the court to peruse it, allow the parties to criticize it or deal with it. Then only perhaps justice can be done. So I think this is really a good development of far-reaching, I would say, consequences.
All right, Mr. Dave, before I let you go, and I know that this is a matter that's in fact just concluded. The hearing is just concluded in the court. So I'll try and elicit a comment from you if you can, or if you're willing to. The matter that was being heard was a petition filed by 14 political parties. Mr. Singhvi was arguing in the court, and the Supreme Court, led by, again, the Chief Justice, saying that, look, come to us for remedy on an individual basis. We cannot opine on a matter that involves the interests of 14 political parties, so to speak. What do you make of that before I let you go, Mr. Dave?
I think the approach of the Supreme Court is absolutely perfect. It's justified approach. I think the opposition parties were ill-advised in moving the Supreme Court. I mean, I cannot think of, going to the Supreme Court as a public interest litigation and say that please do not take action against us, although there may be allegations of corruption against us. I think that kind of an approach was, I would say, it was short-sighted. And judges have rightly, therefore, said that we cannot entertain you collectively, but individually, if you come, we are certainly willing to look and examine whether the material against you is, justified, or whether you are being discriminated against or arbitrarily being targeted. So I think that is a correct approach of the Supreme Court. And I think that no judge would have taken a view different from what Chief Justice Chandrachud has taken today.
Dushyant Dave, always a pleasure. Many thanks for joining us here on CNBC-TV18 on the Court Corner. There's a lot more coming up. Don't go anywhere. We're back in a minute with more.